Kansas landlords need to understand their state's entry rules before visiting a rental unit. Kansas law requires reasonable advance notice, and courts take tenant privacy rights seriously. Welcome to TenantScreeningBackgroundCheck.com. Here's what Kansas landlords need to know about right of entry. Kansas law requires landlords to give reasonable notice before entering a rental unit. While the statute doesn't set an exact number of hours, 24 hours is widely recognized as the standard for reasonable notice in Kansas. Giving less than that puts you at legal risk. Entry must occur at a reasonable time, generally normal business hours on weekdays. Scheduling visits during the workday gives tenants predictability and keeps your entry practices above reproach. Kansas permits landlord entry for making repairs, conducting inspections, showing the property to prospective tenants or buyers, and responding to emergencies. Entry for any agreed-upon purpose is also permitted. Emergency entry without prior notice is allowed in Kansas when there is an immediate and urgent threat to the safety of the property or its occupants. Fire, flooding, or a gas leak are clear examples. If a Kansas landlord repeatedly enters without proper notice or uses entry to harass a tenant, the tenant may terminate the lease and pursue damages in court. Kansas law recognizes the tenant's right to quiet enjoyment as a fundamental protection. For Kansas landlords, give at least 24 hours written notice, have a legitimate purpose, and schedule your visits during reasonable hours. Consistent and professional entry practices protect both your legal standing and your tenant relationships. For complete landlord resources and tenant screening tools, visit TenantScreeningBackgroundCheck.com.